Thank you for listening to Lone Star Community Radio. This program was broadcasted and recorded live from the LSCR studios in downtown Conroe, Texas. Lone Star Community Radio is supported by listeners like you. Donate and sponsor today. For more information on getting involved with Lone Star Community Radio, contact us at lscrstudios@gmail.com or visit us online at www.irlonestar.com.
Hi, welcome to the Legal Connection Show. I'm Toni Collins, an attorney in Texas, and this show airs on Tuesdays at noon until 1. You can hear us on FM 104.5 or FM 106.1. You can also catch our shows on irlonestar.com and go to the Legal Connection Show. Also on our Facebook, the Legal Connection Show, or on YouTube if you miss this broadcast. It's a show that's a community service for the Montgomery County citizens, as well as Texas, if you, or I guess the United States, but since I'm an attorney licensed in Texas, the law that we'll discuss will be Texas law. And today we're going to go over 4 topics that I think that have come up that have been of interest to a lot of my clients and our listeners. Unilateral and bilateral contracts. That sounds so bland, but we're going to go over when you see an advertisement, what your rights are if you go there and there's a bait and switch and the stuff that you have is not there. Also, we're going to talk about commercial leases and what you do if you have a dispute with your landlord, if you rent a small place and you sell cookies, or if it's an office building or a mom and pop shop, whatever it may be. We're going to go over some of your rights under a commercial lease, which are different from your rights under a residential lease. Then we're going to go over the more recent orders from the Texas Supreme Court on residential evictions and COVID and the moratorium and what happens to your property if you're evicted. There's been so many more evictions that are actually taking place now because the moratorium's been lifted. However, there is still money in the Texas Relief Fund in the many places that give you rent relief. They run out of money, but if you reapply, it's still there. So we're going to go over that a little bit too. All right. So to get started today, I just wanted to say I always get off on some sidetracked issue, but I had a client that called me right as I was getting here, and it was sort of something I wanted to pass on. The taxing groups, property taxes or appraisal districts, are sending out your tax notices now, showing what your property is worth for 2021. And because we've had a huge demand and less supply, prices are going up everywhere. And, my specialty is land. I'm getting my master's in real estate land development at A&M. I'm a land broker. I'm a Texas attorney that specializes in title and land issues. And I was a title analyst and a vice president of an oil company for about 20 years. So I'm always very focused on land values. It just intrigues me. And so it's not surprising to me that the value of all land is going up exponentially. Interest rates are phenomenally low right now. They're going up because we've got to, we have an issue with inflation and too much money in our system. But at any rate, interest rates have been really, really low. You can get really good deals. We won't have another 2008 recession because we've now got some stop gaps in place and some safety measures that the government put in place so that the secondary market is protected when they invest. So at any rate, you can get loans more cheaply now than you were able to in the past. And we have all these people that want to buy. And because our borders are open, we have more people coming up from the border who want to buy. So consequently, that's pushing prices up. And so one of my clients called and said, hey, I've got this piece of property and I'm afraid to put it in my name because I went through, it's his homestead. I went through a previous divorce and I don't want my ex-wife to try to think that I have money. So I put it in my parents' name. And so my property's in my parents' name. So my ex-wife won't think that I've got money. it's not worth. I mean, it's worth a lot, but not so much that should be something you worry about. It's just playing with the system. And he said that his tax value doubled. It went from $100,000 land value to $200,000 land value, and that's really nothing you can do about it. I mean, that's just raw land. That's not improvements. That's if the house burnt down and there's nothing on it. That's just because of your location, what your land is worth. And there's ways to fight that, but the best way to fight it is with the law. Texas law provides that if it's your homestead and you've homesteaded it, meaning that, and there's some criteria for it being your homestead, whether it's an urban or a rural, and how much you can claim and that sort of thing. But there's a cap that you can't, your tax rate can't go up more than 10% each year. It will go up more than at least 10% if it's increased in value that much. But for that particular year, it won't double. It won't be 100% more than it was the year before because there's a cap on it by law. But if you're in a situation like my client and it's not in your name and you haven't homesteaded it, then it can go up. So my advice to him, and I guess it would be to you too if you had that situation, is you want to homestead it and be able to prove retroactively that it was your homestead. You just didn't fill out the paperwork. You can do that. You can make it retroactive for the year before, and be able to get that cap. But also, you want to be sure that you file that protest timely. If you file the protest, you can do it online. You go to the taxing authority where whoever sent you the notice. It's usually by mail. If you don't get your mail, though, you want to look into the county online, the appraisal district for your property, and there's a little toggle where you can file a protest. You definitely want to protest it. And then when you protest it, you want to immediately send a letter. You can do this via email, but it's an actual letter. It's just in digital form. And ask for under it's House Bill 201, or it's called a 201 letter. It's not a bill; it's actually a law. It's already been passed through both our Congress and our Senate, or the legislature of Texas. You just send this form. And you can get it if you go to I don't know if it's the appraisal district, or if you email the show, I can send you a copy. It's just a form letter saying I want all of the data that you use to come to the conclusion that my property is now, my land value or my property's worth so much more, or you're not going to fight if it was less. And when you do this, you'll get, if it's commercial, it'll be massive. You'll just get so much data. It's a lot of it's not even relevant. It'll have the different classes of the property, A through D minus whatever the classification or the character of that property is. You want to get it, you want to dump it to an Excel program, and then you want to sort it to only the stuff that's relevant. And then you want to show why they use the wrong comps. And if you do that, whether you do it in Harris County, Montgomery County, Waller County, whatever, it's all the same, the appraisal sort of analysis that the appraisal district uses. You should be able to bring the property value down because they've got so many protests. If you can argue in their language, on their terms, using their data, then you can usually bring down your appraised value. So you have a win-win situation here. You'll be able to bring your appraised value down, and if you properly homestead it, then you're capped off for that year too. And so it will bring your tax value way down, and that's money in your pocket. And if you got the title to your property and it's truly your homestead, you can have one property that's your home, and you meet the criteria of this in Texas. And it used to be that you could kind of fool the system by having a homestead property in each county because there wasn't a central base, but you can't do that anymore. I think you have to, now there's some criteria that they use for your homestead. It may be your taxes. I can't remember what it is, but they know whether it's your homestead now. It might be your driver's license. I just don't remember. But you can't do it in every county anymore. And you're sort of lying anyway, and it's really not worth it to lie because your character is more important than anything else that you have in life. So just don't lie about stuff like that. It's just not worth it. It'll come back to bite you. But if you homestead that property, if it's in someone else's name because you're also trying to protect yourself from a spouse or from judgments or whatever, it's not worth it because your homestead is an exempt property. Your creditors can't come after that. In Texas, we're a really strong state with homesteads. So go ahead and have a gift deed from your parents. So there's no Generally, if it's the gift deed, you're not going to pay any taxes when it transfers, particularly if it wasn't theirs to begin with. It was just a name. So have them gift deeded over to you, or general warranty deed, or whatever kind of deed you need. You can also, again, call the show, and I can help you get the instruments. You don't have to hire an attorney necessarily, or kind of guide you. And of course, there's a disclaimer that you get what you pay for, but this is not rocket science. I can perhaps guide you through being able to get this done in an inexpensive way that will protect you from paying higher taxes, because that's all you're doing. The truth of the matter is, this is your property, it's your homestead. You shouldn't be paying an exorbitantly higher tax rate when you should be able to fight it, and it's just an industry-wide thing, so the government can get more money in their coffers for your taxes. So that was kind of a sidebar, probably a 10-minute sidebar, and something we weren't going to cover today, but very, very important. And one other thing about protesting your taxes is you can do it online. When you file it, you want to ask that it be done online. Your preliminary hearing, whether it be in, again, they all treat it the same, whether it's in Harris, Waller, Montgomery, the Brazoria, the litany of counties that we have that you may have land in. Walker comes to mind. That's the next place I'll be investing in. You want to, the preliminary can be online, and it's usually going to be somebody that's hired by the district, but they don't have the final say. And once you make it through that preliminary hearing and you haven't agreed to what they'll offer you, and generally you don't want to take the first offer, it's not the best offer, unless it's a really good deal and you feel comfortable with it, you can settle your protest and get the taxes to come down at that preliminary hearing. It's sort of a first bite at the apple offer. They make you think that it's only good for the end of the day, but the truth of the matter is it's usually not the best offer. I've never taken the preliminary hearing offer. I learned this from my good friend Crystal, who said she didn't either, and I love her. She's got such a good sense for real estate, her and her husband, that the Wards, I love them. They're just such entrepreneurs. But you want the next phase of your protest will be, again, either online or in person, but it'll be with an actual appraisal board who are usually members of the community that have had a class or some experience, maybe in the years, for looking at these protests and what to look at. You can't argue, it just shouldn't go up, like, this is unfair to me because of my situation. You have to argue their language and logically on why the value that they've used is not a logical value. And you can always win if you've got the facts on your side and you come prepared. You only have a few minutes, but if you're making some sense, they'll give you more time. And if you give it to in advance, or if you forget to give it to in advance, you can bring it that day, and they've got like a little screen and it comes up. I like to do it in person. I like to see people's faces. I like to see who I'm talking to. But you can do it online. And if you do the preliminary one online, it's really best because you're not wasting your time with 1,000 people in some room that's a government room, either off 290 for Harris, and not so bad up here in Montgomery. They get you pretty quick over here off of Gladstone. But still, if you go online, you get the same. It's still a hearing before the board. If they still don't give you what you want, and I've always got I've always felt satisfied after the final hearing. I'll usually come very prepared. If you're still not satisfied, you can appeal that to even a higher court, to a county court. But that's kind of how it works. And don't be afraid of it. Do protest if you don't have your taxes. Do not protest it if you got a really amazing rate and you're just, wasting everyone's time. But I'll tell you this. I didn't protest my taxes on several of my properties for a number of years because I thought, I'm pretty happy with it. It's not that the rate that they're charging me, my tax rate's not that much. It's, I should have been, though, because it wasn't that much. It's not that much work. I actually was able to lower my value on 2 of my properties to lower than it was for the last 10 years. Lower. I was paying, and that's all money that I could have been spending somewhere else. So just sort of a real estate investing thing. Protesting your taxes is not a bad thing. You don't want to waste your time if you can't get a good deal on it. But it's don't be afraid of it, and it is your right if you believe that your property's been overvalued, particularly if it's the land value with the supply and demand issues that are going on right now. All right, now, let me ask Station Manager Dick, how long did that impromptu session on taxes last so I know how I need to craft my time? 15. Oh, my gosh. A full quarter of the show. Something I wasn't even planning to talk about. All right, unilateral and bilateral contracts. This is just something that came up in one of my graduate classes. I just love if you have the opportunity to go to school online, in person, just to learn, just to enhance your knowledge while you're alive, because dust to dust, we came with dust, we'll leave with dust. But while you're here, just enjoy, have fun, be a nice person, be humble and kind, and all this stuff. But it's just this Aggie code that they really reinforce in every one of these classes. It's just every single class, and I don't know which class I like the best. They're all so much fun, and it's just how to be a developer and what you look at, and it's just enhancing my knowledge base on selling houses and building houses and putting streets in and manholes and lift stations and structural engineers and civil engineers and the stuff that I just didn't think that I needed to know, and I really needed to know contours and where you put houses and zoning and that kind of thing. So but one of the classes is a real estate law class, and I thought, well, I don't need that. I mean, I'm an attorney. That's what I specialize in. I should be teaching this class. Wrong. I know nothing. I can't go into. There's not one class that I have not gone into and not learned so much more or enhanced my knowledge base. And one of the things that came up was unilateral and bilateral contracts. I thought, well, I should know that. I mean, I am-jured my contracts classes in law school. No, I just never paid a lot of attention to it. And it's just about when you see ads in the paper, when you go to buy a car, you go to buy a house, and they say, here is, the example would be you've got, 5 fur coats for sale. Not that we have fur coats down here, but let's just say five 2021, like we have cars here now, 2021 Maseratis or Ferraris between 9 and 12 o'clock, first come, first serve. You can actually buy this for $1, and you're thinking a Ferrari, it's worth, $500,000. Of course I'm going to show up. And so once you get there, the Ferrari guy says, well, of course we're not going to sell it to you because it's only for race car drivers, or it's only for females. It's only for, you didn't get here in time, or we were just teasing. And the example that they gave, I thought was, these are real cases that we're learning in this class. The example they gave was, it was a Pepsi. Oh, yeah, it was a Pepsi. It was Pepsi. Was it Pepsi or Dr. Pepper? I think it was Pepsi. They were Pepsi dollars. And Pepsi had a commercial a few years back. I never even saw this, but you can get Pepsi dollars if you bought Pepsis and you saved them. And you could buy a Pepsi jacket or Pepsi glasses and all the stuff that's in this catalog if you accumulated enough of these Pepsi bucks, right? And so they had a commercial where you could buy what's called a Harriet Jump Jet, which I never even heard of. I had to look it up. Apparently, it was a Harrier Jump Jet. Have you ever heard of that? Okay. What it is it was a type of jet that was developed in the early 60s that is like it can lift straight up. It doesn't need a runway. It's almost like a helicopter, but it lifts straight up and it comes straight down, and it was something they were using for our defense, for our national defense. And so Germany made them. They were, I guess, I forgot who the makers were, but the Boeing, they were our big military contracts and our best engineers were developing this Harriet Jump Jet. And so they were actually used, and they can drop little bombs and stuff. I guess we have drones and stuff now, but these things were used. I don't know if they were used in the Vietnam or not. I didn't get that much into it, but they actually would sell them, and they were inexpensive enough that you could actually buy them in the private community. And the value that you can buy them for right now is $1.5 million. You can buy one of these little jets, and apparently they've got a lever and they're pretty easy to drive. And I don't know what the requirements are to drive it, but they're pretty cool if you go Google it. And they're called Harriers because this is a type of bird that's like a defense bird, and it's a bird of prey is what it is. And so these things will go straight up and come straight down, and you can get them for really cheap. And it made my husband want to buy one of these things. And the United States stopped making contracting for them in the late 70s, I think, or the early 80s, and they moved on to a different model. Germany still uses them because they didn't have the money to invest in a newer model, but these things still work, and the newer models are like $20 million. And so you've got this pretty decent little one-person jet that goes up and goes down. You don't need a runway. It's stealth. It operates, and so anyway, this particular little jet was worth about 1.5 million, and so this particular event occurred back in 1976, probably before many of you were born. And so they ran this ad, and they said you get these Pepsi bucks, and they ran a commercial that showed these kids wearing their Pepsi jackets and drinking their Pepsi and wearing their Pepsi sunglasses and their warm up suits and everything was really, for 1,500 Pepsi bucks you get the warm up suit. Well, in the contract, let me go back. In the commercial, they show a kid at the same school in the commercial landing with one of these Harrier Jump Jets or whatever, and he's landing with all of his Pepsi stuff in, and it says basically that you can get it for 7 million Pepsi bucks, right? And so somebody watched this. Some college student was watching this commercial, went and got the contract for how you redeem these Pepsi bucks to get this stuff, and it said you can actually buy these things for 10 cents. You can get a Pepsi buck. So what he did was he went and he got some investors to go in with him, and he collected $700,000 and sent a letter to the Pepsi company and said, I want to buy I'm redeeming my 10-cent coupons, and I want to buy the Harrier Jump Jet. And they said, no, it's not in our catalog. That was just a joke. And he said, no, you advertised. It's on TV. I want the Harrier Jump Jet. And so we went into a lawsuit. This guy sued for $700,000. I think it was more. It was worth more at the time. It's probably worth more like $7 million because they've gone down in value because they're not produced anymore, and it's an older model or whatever. But he wanted this thing, and it was enough. It was important enough to PepsiCo not just to say, just give it to him for $700,000. This $1.5 million Harrier jet, and it went. The PepsiCo sued in federal courts in New York. For under some provision because it was across state lines or whatever. That's the only way you can get to federal court. Is if you have a federal claim, or it's over a certain amount of money, or you have diversity of parties. And so I'm not sure because I didn't look to find out what the terms were that they got in federal court. But PepsiCo filed in New York federal court, and this guy filed in the guy that had the coupons filed in Florida State Court. They consolidated the cases in. PepsiCo filed for declaratory judgment that it was just a joke. It was never meant to be real. It wasn't in their catalog. They said that for various other reasons, we're not going to give him this jet, and no one reasonable person would believe that we were actually going to give a jet. But that's not what the provisions in their particular contract said. And so in Florida, the case was moved. It would have been more favorable if it had stayed in Florida, but ultimately what happened was the key to why this guy did not win the case was kind of marginal. It went on for a long time. In New York, there's a statute of frauds provision that says it's different from statute of frauds says you have to have something in writing. We have a statute of frauds in Texas also. If you buy or sell something that's over $500, it has to be in writing for it to stick. But that doesn't. There's a lot of exceptions to that. So don't I'm putting the disclaimer in that don't rely upon that for your contract to not be defensible or something that you can bring to court. The statute of frauds, though, that was one thing they argued. The second thing they argued was no reasonable person would believe that they were actually giving away a Harrier Jump Jet as a part of their promotion. And because it was a bench trial in the federal court, the defendant, the guy that wanted the jump jet, said, these aren't, a federal judge is not reasonable. They're appointed by the president, and so these are not ordinary reasonable people. And so that was a pretty good argument, I thought. And that may have been good up on appeal too. But the real reason that they won was not statute of frauds, not reasonable person, but because it wasn't in their catalog. They actually had in the fine print that it had to be in their catalog, and the jump jet wasn't in their catalog. Yes, it was advertised on TV, and there could have been an oral, an agreement. But they said this was not a unilateral agreement. It wasn't a bilateral contract. It was nothing. It was just a joke, and no reasonable person would believe it. And so he lost because it wasn't in the actual contract. But it was a great case, and I thought that was kind of funny. And that's the kind of thing you have to look at. So if there's an ad for a car or a jump jet, or you see an ad on TV, or something is like a furniture store, we will, if you come, first come, first serve or whatever, and you bring $1 for this $500 thing, you can actually win if it's specific enough. And so that's what we're going to talk about just briefly today. Like I haven't, given you enough stuff that has nothing to do with the commercial leases, which I really want to talk about today. All right. So this is from Texas Law Help. I love Texas Law Help. It's just like Texas A&M Real Estate Center. They've got really good information, but because you don't have to look it up, I'm going to read it to you. It might be of some interest to you. Now, there's a difference between unilateral contracts, which is like what we just talked about. It's not where it's broad. I'm going to talk about it a little bit better here, but bilateral contracts are contracts where there's a promise for a promise, and it doesn't happen right then necessarily. Unilateral contracts are where it's sort of a how do I say this? I'm going to have to read this and rely more upon what I'm going to read to you than what I'm going to tell you. But it's more like when there's an offer and it's to a group and it's not to one person. It's not specific. But here is the actual law on unilateral and bilateral contracts and why they're different. In a unilateral contract, one party makes a promise to any other eligible party. But in a bilateral contract, two parties make promises to each other. It's tit for tat, like a real estate contract. That's bilateral. I always thought that almost every contract was bilateral, but in terms of if you make an offer to a group to do something, and my professor had such a great example that I've just got to repeat it. He said that he lost the remote to his garage, and he's got 3 teenage kids, and he said, "Hey, kids." To replace it was like $200. It was, for whatever reason, it was expensive for the Genie Corporation or whatever. He told his teenage kids, "Hey, I'll give you $50 if you whoever can find my Genie," and that was better than $200. And he thought they'd jump at it. He said they roll their eyes. He said teenagers, they don't even move for $50. And he said, "Okay, I'll give you $100 if you find it," because there was some motion and they moved around a little bit. They still didn't find it, but it still wasn't interesting. So what that tells me is his kids are either spoiled or the value of $100 means nothing anymore. So I probably would still offer up even more to my kids because it would stay internally and I wouldn't be giving the Genie Corporation, and they're probably the ones that lost it too. But anyway, I thought that was kind of funny. Okay, so in a bilateral contract, two parties make promises to each other. So here's the example of a unilateral contract that is given by Texas Law Help. While strolling along the beach, you notice a sign tacked to a palm tree that reads, "Lost wallet, brown, with $700 in it. Return to owner and receive a $50 reward." It says it has $700 in it. So I don't know. I mean, that's kind of, if you find it, I guess if you're not very trustworthy, you'd just keep the wallet. But a good person would bring it back and give them the $50 because that's what you're supposed to do because God is watching us at all times. Remember that. Don't do the wrong thing. It says, "This piques your interest and you begin sifting through the sand, turning over seashells, flipping beach towels in search of the missing wallet. After all, you could receive $50 and be a pretty good person for it, right?" So you find the wallet under a coconut tree and contact the owner. Return the wallet and collect on the cash reward. So you're a good person. What you really did was enter into a unilateral contract with the owner of the missing wallet. A unilateral contract requires that only one party make a promise that is open and available to anyone who performs the required action, like collecting the reward for finding the lost pet. This sometimes applies to advertisements to that same extent, like we talked about earlier. So the PepsiCo contract was unilateral because it was not to one person. It was broad in the way that it was made, the offer was made. However, advertisements in general cannot be construed as an offer to all parties. In some cases, the courts do consider an advertisement an offer when it contains specific language, like when Bruto's Tacos runs a special for 50% off on tacos between the hours of 4 and 6. 4 taco limit until tacos run out. It's all in the details of the advertisement that creates the unilateral contract. Bruto's ad is clear in that it contains language that the message is sent to anyone who happens to read the ad, but is limited to only a certain number of people who can actually accept the offer. And so if you went there and they had a number of tacos left and it was before 6, like a happy hour situation, and they didn't give you that offer, that would be something you could sue for in small claims court. Small claims court doesn't have you can actually file a petition. It doesn't cost you anything, up to $20,000. Sometimes you get treble damages if the statute provides for it. You can have a Deceptive Trade Practices Act. There's a lot of things you could sue under in small claims court. You don't need an attorney, even for a corporation. And to have somebody serve it, you only have to follow the rules. You don't have to pay a constable $80 to do it. You could fall under a contract and have somebody that's a disinterested party, an 18-year-old, your next-door neighbor, somebody that's not a part of it, to serve it. And so it doesn't cost you anything if you're willing to take the time to do it. These days, you can even do it online. So it may be worth your while if it was a high enough value, or if you got the time for it. But don't waste your time if it was, $559 and, they tried to accommodate you or they had a good defense. So, it's kind of tit for tat. If you want to play lawyer, it can be kind of fun, though, if they really did you wrong and, it might be worth your money. All right. So, for bilateral contracts, it's different. In a bilateral contract, two parties enter an agreement where both parties promise to do something. That would be your more typical contract. That's going to be a real estate contract, leases, to buy a home, to buy a car, not from an advertisement, but you've actually made a deal with somebody. The elements of either contract, whether it be unilateral or bilateral, remain the same, though. So these are the core elements to a contract. So just kind of be aware of this. An offer is made by the promiser. So in the PepsiCo situation, PepsiCo was promising that if you redeem these PepsiCo bucks, you can actually get, the different things that they offer you in their catalog. An acceptance by the promisee. So in the PepsiCo situation, the guy who sent the letter, who collected the $700 from all of his investors and wanted it, sent the letter, and he accepted that offer. With the taco place, you've gone to buy the tacos. You're there between 4 and 6. You've accepted that offer. Doesn't have to be necessarily in writing. It can be an oral acceptance. It's better if you have it with a video, if it's some kind of an offer, because it goes for child custody battles as well. It goes for all types of agreements. You need to have some proof that there was an acceptance. The third thing is consideration or support for the offer, like money. So if it says you need to bring $1, you need to show that you brought the consideration. The PepsiCo situation, he had the $700. If you show up for the taco place, you've got to be able to pay for that. If it was a bilateral, if it's a promise for a promise, so it would be I guess in the situation where you have a real estate contract, you have submitted your earnest money contract, so the acceptance will be whatever that, when you enter the money and gave it to the title company. And I just wanted to, as a sidebar, say that when you enter a deed in Texas, or when there's actually a deed transaction, or if you've gone to buy a house, you'll see in the deed, it doesn't say, most of the time, it doesn't say the amount that you paid for the house. It says for valid consideration or for reasonable consideration of $10, or whatever it says. There's some terminology in there, and that's odd. You think they didn't pay $10 for this house? That can't be. Of course, I can win this contract. I can renege, not renege, but I can revoke or rescind the offer. I don't want to sell it to them anymore because they didn't have. There's no valid consideration. I didn't want this house. I want them to take it back. But in Texas, you don't have to. The $10 consideration is. It's sort of a privacy confidential thing. The $10 works. It's valid because between the two parties, you'll be able to prove up later what you actually paid for it if you really go to court over it. So the $10 consideration is not something on its face, prima facie argument that they didn't have valuable consideration. There's actually statutes that exempt that. The fourth condition is you have to have legal capacity, meaning both parties are free from mental illness or addiction. And they can't be a minor. Usually if a minor enters a contract, they have to be they can't be a minor, they have to be emancipated, or they have to have their guardian, which is their parent, not modify it, but adopt the contract for them, or that is a voidable contract. It's not void, but it's voidable because they don't have a capacity, because minors don't have the capacity to enter a contract. So if you're at a lemonade stand and two kids are arguing over something, you could say that they had a contract, and there is some argument about that, but it's going to be, it won't help in court because you've got two people that don't have capacity arguing with each other. And so best to have their guardian involved, and then the guardians can actually file suit if there's some argument with that. And then the final thing is there has to be lawful terms. You can't enter a contract for illegality, and that's one of the affirmative defenses. I'm doing a case right now where a contract was entered between two. I don't want to get too much detail in the case because I don't want there any privacy to be privacy issues to come forward, and it's still an ongoing case. But basically, you cannot enter a contract if it is illegal. And I guess a good example is we have and I'll go into a land situation. If you've got if a developer buys land from somebody and the land that they buy is not owned by them because the person saying that they own it didn't own it. It was owned by somebody else because they never had title. So somebody sells you land to something where they didn't have the title to begin with because they just said they had it and they were lying, or maybe it was just they didn't know. Whatever the case may be, if they didn't have title, and let's say the reason they didn't have title was because in the situation I'm working with, there was a void judgment because the person that there was a I'm getting really way too deep for this. Let's just say that they didn't have title and it was void. If the title that they gave you wasn't valid because they didn't acquire title, then that is void. They can't pass title on. If a party enters a contract with someone who didn't have capacity because that people always like to say they entered a contract while they were drinking on a napkin or something. That's voluntary incapacity, and it's not going to work most of the time if they can prove that it was a voluntary incapacity. That's why people try to argue, in criminal court, well, I was drinking and, it's affirmative defense. I didn't know that I was drunk because I was drinking, and it's the, dram shop rules where the bartender knew I was, you can sue them later because they served you too much, and they win cases like this all the time. So there's a lot of layers of these cases, but if it's not a defense to say that you were drunk most of the time because that's a voluntary incapacity unless you were drugged or you can prove some other way. But it's voidable if there's an incapacitation. If it's an illegality, it's void, okay? And so lawful terms is really important. You can't enter a drug deal with a drug lord and then he didn't come through with his provisions and then go to court to sue him because the drug deal was illegal. And there's a lot of exceptions when you've got, the police involved and, and various other things that when there's a reason for it. And, I don't want to get into that either. But for the most part, illegality, not going to work, void contract. You've got to have offer, acceptance by the person that they're accepting the offer, if it's bilateral or unilateral, consideration of some kind. It has to be reasonable consideration, but if it's in a real estate contract in Texas, if it says $10 or reasonable consideration, that may just be on the surface of the deed. That's not actually the consideration that was paid for it. But again, if you bought a house for $10 and you really only paid $10, but it was worth, and the person you're buying it from was senile, you don't have a good contract because you've got improper consideration, you have incapacity of the party, and you may have legal terms, but you're missing 2 of the 5 prongs here, so you would be able to get that contract thrown out. Okay, so a unilateral contract, like we just talked about before, is a contract in which one party makes a promise to whomever takes action as prescribed in the offer. In this case, the wallet was the action taken by you, and it was to keep it simple. The promisor was the owner of the missing wallet. I think we kind of went over that. It was an acceptance. So the consideration was $50. That's what they paid. They fulfilled their part of it. There was legal capacity by both parties, and there were lawful terms. It's here that you happened upon the palm tree bearing the grim news of the missing wallet. You were in no part a part of making the unilateral contract. This is exactly how a unilateral contract works. The promisor makes a promise to whoever is willing to act on it. There is no promise until the action is complete and the exchange is made. The unilateral contracts are always enforceable if they're specific enough and you've met all 5 of the terms. It says, using the wallet to stress this point, had the owner of the wallet refused to pony up the cash reward, you could take legal action against him because the reward was posted as an advertisement, and you would not have searched for the wallet had you not known it was missing. And, of course, you would have to prove that the contract existed, the reward signed on the tree, the contract was reached by the promisor failing to provide the reward money, that the promisee you suffered a loss as a result, the time you spent looking for the wallet, and the person that allegedly lost the wallet, where the promisor was responsible for the loss, refusal for payment returning it. If all these things occur, you have a very good chance. In fact, you will win in court if you're able to prove all those things. It's just a matter of you proving that up. And so now that I've spent almost the entire show on something that I plan to spend the first 15 minutes on, I'm going to ask Station Manager Dick, how much more time do I have left in my segment? So I know which 15, yes. I can get to the commercial leases, something that I've been trying to attack since I was here this morning. Commercial leases. This is an article from the Texas Law Help Group, and it came about because I have so many clients that are both landlords and tenants for commercial leases. We're not talking about residential. We're talking about a situation where you've got some property and you are leasing to somebody who wants to run their business, whether it be in a small food truck or, a huge office building. It's still all the law will pertain to you the same way. And so the question that one of my clients had, and this is how this came up, is I have a dispute with my landlord. Now what do I do? I mean, they're just they're new to this. And so the first thing you want to do is review your lease to see if it states how the dispute should be resolved. Keep a record of the problem, the copies of any related letters or receipts. And, that's easier said than done if you've had somebody there for a while, and this is just kind of a handshake deal. But, commercial leases should always be in writing. You can get them, you can download them from if you just Google commercial lease in Texas Law Help, they can get you to it. If you go to the Texas Real Estate Commission, they've got the Texas Area Realtors commercial lease form. It's a toggle form. You can fill it in actually on the form, and it gives you a lot of protection. It was promulgated by the Texas Real Estate Commission lawyers. The lawyers that represent that commission there's 9 people on a panel. They've got 9 lawyers, 9 residents that are selected, and 9 real estate brokers, I think is what it is. And it's a very, very good lease. You want to enter that commercial lease, even a residential lease. You want to enter a lease that's in a form that's promulgated. If at all possible, it's going to give you a lot more protections than you would have otherwise. All right, so lockouts. Can your landlord, know this, can lock you out for non-payment of rent or for abandoning the property, unless it says otherwise in your lease, and it won't if you've got a promulgated form. I will add this also. You have to read your lease because the lease can override some of the standard provisions. Like it may say you have to go to arbitration. It may say the first step in resolution for dispute is you have to do certain things. It may be that you had a lease that was negotiated by somebody that, or maybe it was an attorney that wrote the lease and it's got some different special provisions on it. But do read that first. That's the first place you want to go. You want to kind of see where you stand, right? And then look at the facts of the dispute. You want to collect that information. You don't want to jump the gun and just believe your tenant, or you want to go see what's going on. Facts, knowledge is power. So I think the first thing I do when I get any tenant calls from clients or otherwise is I want to listen to the facts. It may be something that it's just a misunderstanding. It wasn't something that was wrong at all. But listen to the facts and then go read your lease. Those 2 things are important, and then collect more facts if you need to before you say something that you might that may be wrong, that may create more of a problem than you don't even need that, because it's just a misunderstanding or miscommunication. All right, so if the lockout notice is for non-payment, the landlord must post written notice on the front door with contact information for the person or company who can provide a new key during normal business hours if you're locking them out because they haven't paid. This is different from residential. You can't just have a lockout notice for residential. So this is strictly looking at commercial. You must, if you are the tenant, you must pay the delinquent rent to get the key. Lockouts can also be for remodeling, construction, repairs, or in an emergencies. I think I guess you would have a lockout notice if you had something where there was like happened in Austin, if a tornado hit, and there would be some liability to the landlord, depending on who insured what. You may need to lock your tenant out, even though I don't think you'd want to do that in an emergent situation, to protect, for premises liability purposes. You don't want to protect other people from just coming in there. You may need to, like they've done, the city of Houston does when there's a fire, and you may need to do this too if you're the landlord. You need to put a fence around it to make it so it's not an attractive nuisance, or to protect other people. If it's a dangerous situation, in a very timely manner, you need to fence off your commercial property if it is deemed a hazard, because there will be a liability to you as a landlord. And yes, your insurance will protect it, but your insurance policy is also going to say you have to take reasonable steps to mitigate any further damage, and so you need to look at that thing. So I'm looking at the situation that happened in Austin. These houses, it's just phenomenal. If you go to the paper this morning, I could not believe that we were saved from all of this, the weather torment. And I was talking to one of my friends, saying, "Did you see that the roofs were blown off this house? It was just crazy." And I just in passing, I said, "I wonder why Montgomery County, was saved from this." And I'd like to think it's because we are, God is shining down upon us, and He's liking our conservative ways. But my very conservative friend thought that was funny. But that's, I don't think that these people were any, conservative or liberal. But it looks kind of dangerous as it stands right now. It looked like only 4 people were injured in Round Rock. That is phenomenal if you look at the damage that took place. But if you look at the way the houses looked, and you look at the severe damage that occurred, it occurred to me that there may be gas leaks, gas line problems, electric lines. A lot of people were injured during Hurricane Harvey when electric lines were live. So be very, very careful if something like that happens, and shut off your utilities in case they come on again, and protect yourself. If in doubt, you can go to FEMA. Will have a page on the things that you need to do. Texas Law Help, or your insurance company. Those are the best people to call immediately to find out what you need to do in the event of some kind of a natural or other type of disaster. Now, security deposits. A security deposit is separate from your rent, and you cannot use it as a substitute for rent. Your landlord must refund your security deposit within 60 days of your move out, or from the date that you provide a forwarding address. Your landlord cannot deduct for normal wear and tear to the rental property. Deductions can be made for damage caused by you or your patrons, including damage caused by removing your equipment when you move out. If deductions are made for repairs, your landlord must provide an itemized list of each repair, the cost, and the remaining balance of the deposit, if any. If your landlord won't refund your deposit, you can sue in justice court for the refund along with court fees and costs. Now, if your move out was not a proper move out, there wasn't the proper notice, if it was named more abandoned property, that is a different animal. You don't get your deposit back because you're still subject to the lease. Your move out has to be a move out subject to the terms of the lease, not I just want to move out, so now I want my deposit back, because you're still liable for the terms of that, whether or not you're in the property or not. You could sublet it. The landlord needs to mitigate, but that is we may get into that in this particular segment, but with regard to security deposits, I wanted to sort of clarify that. Now, how can I get out of my commercial lease? Let's say during COVID, you couldn't get out of your commercial lease, but you could ask for help through the government for the different relief loans and grants, and many people got them fraudulently, depending on the size of your business. A lot of people got them properly. A lot of people still were able to run their business, and they weren't hurt by COVID. So, but let's just say you want to get out of your lease. You don't like the location, whatever the case may be. Read the termination clause in your lease. If you quit the lease early, you are responsible for the balance of the lease, all the way to the end of the term. For an example, if the lease term is 1 year and you leave 5 months early, you can be liable for the remaining 7 months of rent, the balance of the term of the lease. Consider negotiating a shorter term until you're sure your stay is up. Now, what happens if I vacate? Can my landlord keep my equipment? Well, it depends on the terms of the lease, and also depends on whether the equipment is considered a trade fixture or an improvement. Trade fixtures are things that you purchased and installed are attached to the site for business purposes. For example, display counters, signage, other equipment. A trade fixture can be removed if one, it is necessary for your business. It can be removed without damage to the property, and you can remove it promptly. If you move and lease property behind, you have 60 days from the date that the landlord stores the property. If you leave it behind, if you move and leave the property behind, you have 60 days from the date the landlord stores the property, either on the site or another location, to claim it. If you don't, the property is considered abandoned, and the landlord is free to sell it or dispose of it. So 60 days, you got to pick it up. If you don't, it's abandoned. The landlord is required to send a letter by certified mail to your last known address informing you of that particular deadline. And I would just add that there's a lot of cases on when something becomes a fixture and when it doesn't. In Texas, if you have an AC unit and it can be removed without damaging the property, and it's on the roof, then the AC unit, if it's a particular unit size and SEER value and what have you for that particular business, it may not be considered a trade fixture, and you can actually remove it. If you have installed counters, then that's going to be a trade fixture, and you have to leave it. It's an improvement that you're generally going to have loss of the lease unless you say otherwise in the lease, and most people don't. If you are mad because you want to leave early and you pull these fixtures out and you damage the property, then you will be responsible for the cost of the fixture removed and the damage you caused the property removing it. If, though, for an example, you and the example in Texas, there was a case where there was a person that built all these apartment complexes, and they built all the units, and they were fairly new, but it went under for some reason, and the unit owner who left took out all the refrigerators and the stoves, the countertops, and there was one other thing that had some value that they took out. Can't remember what it was. But anyway, what it came down to was the Texas court said, we have no problem with you taking the refrigerator and the ovens, which you'd think would be a fixture typically, because you can just unplug them and move them, and it didn't damage the property. But the stuff that was affixed in any small way that was modified to fix that particular property ended up being a fixture. So the countertops, and I think it was sinks or something that didn't seem like it was a fixture. It may have been their big screen TVs, but it was something. It ended up being a fixture the way they had installed it. So that's kind of the rule of thumb. But if in doubt, contact an attorney. But trade fixtures usually do stay, unless you can prove that trade fixture was something that was esoteric to your particular business. Now, improvements, and I think we talked about that just a little bit, include property that is stuck to the ground in a more permanent way, like a storage shed. So trade fixtures installed are attached to the site for business purposes, can be removed if it's necessary for your business, can remove without damage, and you can remove it promptly. So if you had a particular type of cabinet for your ice cream or something, that's a trade fixture because it's an ice cream shop, let's say. It wouldn't be if you didn't have an ice cream shop and the way it was affixed didn't meet this criteria. If it wasn't necessary for business, or it could not be removed without damage, or you don't remove it promptly, then the landlord gets to keep it. Improvements are different. Improvements include property that is stuck to the ground in a more permanent way, like storage shed or a fence built onto the property. Improvements usually remain with the property of the landlord, even if you installed the improvement. If you aren't sure whether it is a fixture or an improvement, consult a lawyer before you remove it. But if you install an elevator, if you build out the property for your temporary build out, if that's going to be usually considered an improvement, it's going to go to the landlord, and they don't get to deduct, you don't get any money back for that. Now, should I sign a lease under my name? If you are in a partnership, an LLC or a corporation, which you can set up under the SOS for almost no money, you can do it online now. There's some criteria, and they take about 8 days to approve it to make sure you're creditworthy and various other things. But you can set up these entities. You should sign it on behalf of the business, not you as an individual. If you are a sole proprietor, unincorporated, you must sign as an individual. On our leases, we usually get an individual grantor from the person that has set up these partnerships because really you don't have any protection unless you have somebody actually putting their name down saying that they will be liable individually for it. By signing individually, you agree to be personally responsible, or if you're the guarantor for it, for rent and other expenses under the lease. Otherwise, the business entity is responsible. I'm getting the wind it up notice from station manager Dick telling me that I have once again not finished what I want to talk about. But next week we're going to talk about, does the lease have to be in writing? Of course, I will tell you that it always needs to be in writing. Statutory frauds. Can I negotiate terms of commercial lease on my terms? As we just talked about today, I think it's a much better idea that if you do negotiate it, that you use one of the promulgated forms under that's offered free of charge online at the Texas Real Estate Commission, and various other topics. Next week, we're going to talk about personal property eviction, what happens to it, rights to repairs as a tenant, roommates, and what you need to look for when for your protections if you're going to get ready to rent a lease property now, because more people are starting to require to be working from their actually brick and mortar and not from their houses now that COVID's kind of winding down. So I will see you next week. Legal Next Show. Remember to serve God by serving others, the most important thing that you can do. And I will see you next week.